But the justices thought this intellectual exercise illegitimate. I mean, not wrong in the sense that the litigant had misunderstood the likely behavior of the legislative branch, but wrong in the sense that judges aren't authorized to engage in the exercise in the first place. And I'll quote a little from this opinion. Usually quotations pose the risk of boring you, but this is an interesting quotation, so follow along. It says, "The litigants, at least, ask us to guess the preferences of the enacting Congress. Justice Stevens apparently believes that our role is to guess the desires of the present Congress, or of Congresses yet to be. Quote, only time will tell," close quote, he says, quote, "whether the court, with its literal reading of 1988, has correctly interpreted the will of Congress," close quote. The implication is that today's holding will be proved wrong if Congress amends the law to conform with his dissent. We think not. The will of Congress we look to is not a will evolving from session to session, but a will expressed and fixed in a particular enactment. Otherwise, we would speak not of interpreting the law, but of intuiting or predicting it. Our role is to say what the law as enacted is, not to forecast what the law as amended will be. Or to put it otherwise, I'm now done with the quote, to put it otherwise, the only will of Congress that counts is a will that satisfies the bicameralism and presentment requirements. Now that's reason one. Reason two is that limiting interpretation to the work of the enacting Congress honors the reality that laws are enacted as packages. Arguments that today's Congress would do X or Y or Z with a given issue suppose that the legislature will act on that issue all by itself, and that an opinion poll or perhaps the report of the majority whip tells us what outcome a majority favors on that issue. But if a given proposal has widespread support, someone always adds an amendment about a contentious subject in order to help a less favored proposal go forward. And just think, for example, of the anti-abortion clause recently tied to the pending health care package. And suddenly things aren't so clear in the legislature anymore. I mean, my example here is the Civil Rights Act of 1991. That statute changed several provisions in civil rights laws that the Supreme Court had construed favorably to employers. And the justices in the dissent in those cases were sure that the legislature would overturn those decisions. But the 1991 Act also changed some decisions that had favored plaintiffs. For example, it changed the Albemarle paper decision, which had allowed differential validation of employment tests. The 1991 law also set caps on damages awards. The pro-worker provisions could not have passed without the pro-employer provisions. Any attempt by the judges to discern what Congress would have done on one of those issues, standing alone, would have misunderstood how legislation works, because the issues never stand alone. My third consideration is entirely prudential, and it is that judicial attempts to predict what Congress will do come croppers more often than not. Here, my favorite example is Illinois Brick Company against Illinois, which held that only direct purchasers may sue under the antitrust laws. And what that means is that if steel manufacturers get together and form a cartel, the right plaintiffs are the auto manufacturers who buy the steel rather than, say, automobile buyers who buy cars that contain steel. Justice Brennan predicted in dissent that Illinois Brick would be short-lived because Congress was sure to allow indirect purchaser suits. Like Justice Stevens, he called on his colleagues to recognize that political reality and interpret the law to allow those suits without all the fuss and muss of actually getting the amendment through Congress. The majority was unpersuaded. Well, here we are, 32 years later, and Congress has not allowed suits by indirect purchasers despite persistent proposals. Judges may be, and they are, I think, very bad at understanding what can be enacted, but they're very good at understanding their own views of wise policy. When a judge says, "I'm confident that today's Congress will enact Proposal X," what this really means is, "I favor X." But a judge's preference for X is just a very bad reason to declare that X is the law, Again, we need to remember that our Constitution's design is to keep policymakers on short temporal leashes. Judges don't stand for election, and it follows that they can't make and adopt their own legislative proposals. And what I've said about using the sitting Congress as the basis for interpreting older statute goes for the method of imaginative reconstruction. That is, asking what the enacting Congress would have done about something had they addressed it directly. Such an approach ignores the package deal nature of legislation, and if you think judges are bad at predicting what today's Congress will do about a topic, think how awful they would be at estimating how people who died 50 years ago would have done at handling the topic. There's a case that I will just refer you to, and perhaps we'll talk about more in the exchange later. It's a case called Logan against the United States, where it had to do with the question whether somebody can have his civil rights restored when they have never been taken away. Now, that's a question only a lawyer could ask, right? There is a federal statute which says that you get a recidivist enhancement if you commit a certain offense twice. How do we know whether you've committed the first offense? Well, that's determined under state law. What does state law do? Well, the statute says if your civil rights have been restored following your state law conviction, we won't count it, and you don't get the recidivist enhancement. What happens if in a state like Wisconsin, Wisconsin just doesn't take away your civil rights when you're convicted of crime, and you can go right on voting from prison, right? What happens then? There was a very odd possibility that the less important the crime, the less likely your civil rights are to be taken away, therefore the less likely it is you will ever get them back, because you can't have them restored. One court of appeals said, well, that's so outre that what I will do, the author of the opinion said, is I'll just put the question to the enacting Congress and figure out what they would have done had they thought about this concretely. Case came to the Seventh Circuit, and we said, for reasons you can now tell, that's not a legitimate method, right? We disagree. But the pièce de résistance was that, unbeknownst to the First Circuit, Congress actually had confronted that question directly in another statute passed at just about the same time, and they had said in so many words, oh, by the way, the fact that you never lost any civil rights doesn't mean you should be treated the same as somebody who lost them and then had them restored. So it turned out that not only was there a problem of legitimacy of the method, but the judges were really bad at figuring out how Congress would address this issue. And I wrote an opinion hoping to provoke the Supreme Court into addressing the fundamental issues with the method of imaginative reconstruction. The justices ended up affirming my opinion in an opinion that seems to have been written for the purpose of ensuring that no one would ever read it. Confronting none of the fundamental issues and just saying, well, yeah, the language was plain, so what can we do? If you never lose something, it can never be restored. So we don't have to think here anymore. Well, look, from what I've said, you should know that I'm in favor of judges not thinking.
Clearly.
The more thinking they do about statutes, the more things can go wrong. So I will, with that endorsement of empty-headed literalism, I will hand things over to Judge Calabresi.
Thank you.